بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيد المرسلين وعلى آله وأصحابه الطاهرين ما دام ما في السماوات والأرضين رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما اللهم إنا نسألك علما ينفعنا اللهم إنا نسألك علما نافعا ورزقا واسعا وعملا متقبلا وشفاء من كل داء نوينا التعلم والتعليم والتذكر والتذكير والإفادة والاستفادة والحث على التمسك بكتاب الله وسنة رسوله صلى الله عليه وآله وصحبه وسلم وبعد السلام عليكم ورحمة الله تعالى وبركاته. I'm thinking now about something somebody sent me. But I can't recall it directly. It relates to smiling. So we know from the prophetic tradition, the Prophet sallallahu alaihi wasallam says, لا تحقرن من المعروف شيئا ولو أن تلقى أخاك بوجه طلق. Don't consider insignificant any good deed, even if it be that you meet your brother with a smiling face. And we know the Prophet ﷺ used to smile quite a bit, but sometimes circumstances. So the saying was along the lines that let not the circumstances cause you to lose your smile. Continue to smile. You know, whatever your circumstances may be. May Allah subhanahu wa ta'ala keep you and I smiling. Without further ado, alhamdulillah, we've covered quite a few lessons. We're now into lesson number 9. And in terms of our last lesson, we had looked at the fact that the contracted item, it must be known. If you're purchasing something, you must know the item that you are purchasing. In other words, the corporeal. You must know the extent of the item, and you must know the qualities of the item. An example which comes to mind now would be material. If you're purchasing material, so you know what material you're purchasing. You know the extent. Is it 1 meter? Is it 2 meters, 3, 4, 5 meters? So you know the corporeal, its material. You know the extent of the material, and you know the quality of the material as well. Is it white cotton? Is it blue cotton? Is it nylon? Whatever the case may be, that would be an example. The point that we're coming to now would be looking at the quality of what you are buying, the qualities of what you are buying, the characteristics of that which you are buying. A person must know that from the outset. Now, when we look at this in terms of Quran, a foundational verse would be لا تأكلوا أموالكم بينكم بالباطل إلا أن تكون تجارة عن تراض منكم. Allah talks about the exchange of wealth. So wealth should be exchanged based on mutual consent. When we look at these conditions, we would find that they would somehow or the other, either directly or indirectly, they would compromise the mutual consent, happiness. You buy something, you don't know exactly how much you're buying. So when you buy it, afterwards you look, I thought it was 100 meters, but now it's only 50 meters. So now that compromises the mutual happiness and the consent between the two parties. So that verse is a very important verse to keep in mind. And all of these conditions, Allahu A'lam, basically stems off from that particular verse. There must be mutual consent. You give me the material, I give you the monies, you happy, I'm happy. Whatever compromises that would, in all probability, render the contract null and void. It would vitiate the contract. What we're looking at now would be the qualities and the characteristics, particularly in today's time. And last week we broached this very important issue. Generally in today's time, when you go to a given store, you are not buying in rem. In other words, you're not buying that specific item. In rem would mean that I'm selling you, I'm looking for my phone now, or rather let's use a book as an example. I sell you this book. I sell you this book for 240 rands. So this particular sale is an in rem. In English they call it in rem, because I'm not selling you a book, I'm selling you the book. Now, so that's generally in our classical fiqh. the rules are generally written with the in-rem sale in mind. I'm selling you this item. Okay? Now just fast forward to today's time. When you go into a store, generally you don't buy the item, you buy an item. So it's not necessarily in-rem. And that later on in terms of the class, I'm just like doing an executive summary of the class. Later on we'll look at, you either purchase something which has been described, or you purchase an item in rem. That's what happens in today's time. Even, for example, you go to a store in South Africa, a retail store, a big retail store, like everything under one roof, would be a store like Macro. So you go into Macro and you're purchasing a fridge. Now, when you purchase the fridge, it's not the fridge, the one that you're seeing. You're seeing like a prototype of the item that you're ultimately getting. Because what's going to happen is you're going to pay for it now. But your fridge is currently at the warehouse. So you have an option to collect it at the warehouse or an option of delivery. So it's not in rem. My point now is not about the nitty-gritty about it. My point is that you're not purchasing in rem. You're purchasing an item, or you're purchasing the like of an item. There's a different issue altogether whether, when you see the like of something, will that suffice? Wallahu alam, but it would suffice. But we are talking about when you purchase at a given retail store, you're not purchasing the item, you're purchasing an item. It's an important consideration to keep in mind. Whereas yesteryear, it would more or less, the default yesteryear would be that you're buying in rem. And you're not buying an item, you're buying the item. And Allah subhanahu wa ta'ala knows best. So we're going to look through some of those particular issues. And the chapter heading reads, Ma'loom al-sifat wal-qadr. That the item that you are purchasing, it must be known in terms of its qualities and in terms of the extent. So we gave the material example. Is it cotton material? That is the quality. Qadr means how much meters are you purchasing? Are you purchasing 5 meters, 10 meters, or so forth? وبعد أن عين المعقود عليه ذاتا بقي أن تتعين صفاته وقدره التي تختلف به الأغراض. So having ascertained the corporeal that you are purchasing, like I'm purchasing this item. So if you think of a traditional marketplace, and you still do have many of these markets, particularly in the Middle East. So you come across a vendor. The vendor is selling wheat. So it's basically the wheat. But now what happens is the wheat may have different gradings, different qualities. And then how much do you want? Do you want 1 kg? Do you want 2 kgs, 3 kgs, whatever the case may be? فَلَا يَكْفِكَ أَن تَقُولُ. So it would not suffice you to say, for example, بِعْتُكَ هَذِهِ سَيَّارَةً بدون أن تصفها بما تحتوي عليه من الصفات. It would not suffice a person to say, I sell you this car. Now, technically speaking, in terms of our school of thought, when you see something, you consider to have knowledge of it. And you can get away with it, even though you may not know what exactly the commodity is made up of. You may not exactly know what the commodity is made up of. But because you're seeing it, your sight of it is construed as having knowledge of it. So therefore, technically speaking, the sale would be valid as long as you saw the item. But we're talking along a different line here. So we'll continue inshallah and we'll become self-explanatory bi'idhnillah subhanahu wa ta'ala. فَعِنْدَمَا تَبِيعُ سَيَّارَةً لَابُدَّ أَن تَقُولُ. So when you are selling a car, by way of example, this is particularly salaman now, like in the forward buying, which we will allude to later bi'idhnillah subhanahu wa ta'ala. فَعِنْدَمَا تَبِيعُ سَيَّارَةً لَابُدَّ أَن تَقُولُ. When you are selling a car, it is necessary for you to say sayyarat. I was thinking of an example at the time, Toyota, in terms of the brand, al-ikhtisasiyya, bayda 2020, sedan, ذات 5 أبواب, 5 door, وطاقة المحرك كذا وكذا ولو مجرا, and the motor specifications need to be mentioned. So importantly, when you are buying something, and we will look in terms of how you are buying it, one needs to know the specifications of what you are buying. Now, so we gave the example of a car. So you know the car that you're buying, you need to know the specifications of the car. تنبيها يشترط وصف المبيع إذا ما كان في الذمة. This is the point that I mentioned earlier on, because this text really relates to when you're purchasing something that is described to you, then all of the descriptions need to be made. But when something is in front of you, this is important to understand from the Shafi perspective. So when something is in front of you, like I say to you, I hereby sell you this car, and the car is right in front of you, you're able to see the car, then your viewing the car is construed as you having knowledge of what you are purchasing, and therefore the sale is considered valid. So ru'ya, if you wanted to take the place of ilm, or ru'ya is a synonym to ilm. When you see something, you are considered to know it. So therefore there's no issue, there's no, you see the item, and when you see the item, you are considered to have knowledge of the item, and therefore the sale is going to be construed as valid. However, when you're forward buying an item, and this is the default in today's time, when you're forward buying an item, then that item must sufficiently be described to you. Tamam? So there's a sale. In other words, I sell you this phone for 10,000 rands, by way of example. Here's the phone. You see the phone in front of you. You give me the 10,000 rands. You take the phone. You consider to because you've seen the phone, so you know the phone. You consider to know the phone. If I'm going to forward buy it from you, I'm going to pay you 10,000 rands, and you're going to deliver a phone on the 1st of next month. Then all the specifications of the phone must be mentioned contractually. Otherwise, the sale is going to be invalid. So, يشترط وصف المبيع إذا ما كان في الذمة. Describing the commodity is stipulated when the commodity is described in the seat of responsibility. أما إذا رؤية, as for when the item is seen, in other words, it's in rem. فلا حاجة في الوصف على ما في مذهبنا كما سيأتي مع مناقشتنا بعد قليل. So, in terms of our school of thought, when the item is seen, then this viewing suffices, and the item is considered to be valid according to our madhab. But we're going to discuss that, and we're going to have a bit of a to and fro in that particular regard. على أنني وجدت مسألة يشترط فيها الوصف وهو ما إذا كان المبيع قد رؤي من قبله وهو مما لا يتغير غالبا أو يحتمل فيه تغير وعدمه فيشترط أن يذكر الأوصاف حال العقد. I found one particular instance whereby despite the fact that the item has been seen, I'm inclining towards the following, and that is, don't suffice yourself by seeing the item, but rather when you see the item, enlighten yourself as to the specifications of the item, the specs of the item. So see the item, familiarize yourself with the specs of the item, and then purchase the item, so you know what you are purchasing. So classically, I came across the following example. We will see later that one of the conditions of a valid purchase is that you must see the item. So what happened was, Mln Yahya is in class. So you see the Atom Mini here, right? I meet you a week down the line, and I say to you, I am selling the Atom Mini. I hereby sell the Atom Mini to you for an X amount of money. You agree. Tamam? So now what happens is, at the time of the sale, is the Atom Mini present? No. I meet him in the mall, I meet him in the mosque, I meet him along the way. But because you saw it previously, that previous sighting would suffice. However, they recommend in this particular, rather, it is stipulated that when something was seen before and it does not change generally, or there's a possibility of it changing, that it's not present at the time of sale, but I must describe it to you so that we know exactly what we are contracting on. So I must say, Yahya, you know the Atom Mini that you saw, it's an Atom Mini Pro. It has so much prongs, it serves this particular, these are the specs of it. So in that particular instance, when the item is not present, what must happen? despite the fact that you saw it before, the specifications, the specs must be mentioned. So this is an important concept for me, because I want to build on our approach to buying and selling in today's time with a focus on knowing the specs of a given item. So in our classical fiqh, we have this example, and I'm going to run through it again, that a normal sale, here's this item here, Mawli Yahya can see it. I say to him, I hereby sell this Atom Mini Pro to you for 12,000 rands. Mawli Yahya says, Ishtaraytu minka, I hereby purchase it from you. No questions. He saw the item. Because he saw the item, he's deemed to know the item, and the sale is valid. That's scenario number one. Scenario number two is we have a situation whereby Mawli Yahya sees the item. It's right here in front of us. Then what happens is, I have no intention of selling the item. A week later, what happens is, I meet Mawli Yahya. تفضل. بسم الله. أهلا ومرحبا. كيف حالكم شيخنا يوسف؟ مرحبا مرحبا. أنت تكون معنا. So what happens is, a week later, I meet Mawli Yahya, and I say, you know the Atom Mini Pro that we use for the class? I'm selling it. So now, is the Atom Mini Pro present at the sale? It's not present at the sale, but Mawli Yahya saw it before. So that previous citing of the commodity is valid, because point is that you saw the item. But now what happens is, our scholars stipulate that because the item is absent, you must mention the specifications of the item. So at the time of the sale, I'm going to say to Mawli Yahya, look, I'm selling you the Atom Mini Pro, the one that you saw. It's an Atom Mini, it's a Pro, it's a 2019, it has these functionalities. So I have to describe the item to him in that particular instance. Now the point why I'm highlighting that is because in today's time, what happens is you find that there's an item, you see it right in front of you, but the value of the item is not really in terms of the outer shell. It's really in terms of the specifications. So you need to know the specifications. So in today's time, Allah SWT knows best. More important than seeing an item is knowing the specifications of the item. When you buy something online, you're also concerned about how it looks, the aesthetics, but you're more concerned in terms of the specifications. One laptop might look exactly the same like the other laptop, but the one goes for 10,000 rands, the other one is selling at 50,000 rands. What's the difference? The difference is the specs. I couldn't believe it. Myself, Mawli Yahya, and one of the brothers, we went to purchase a hard drive. So a hard drive looks like the size of a flash drive. But the difference in terms of the storage space, which reflects itself in the price. Like, I was shocked that you get a hard drive that costs something like 3,000, 3,500, and even more in terms of a hard drive. So it looks the same, but the specifications are different. So therefore, in today's time, the type of commodities that we are dealing with, the specifications are very important. So classically, we would rely on citing. And that's basically what our school of thought says. In order for the sale to be valid, if you saw the item, then the sale is valid, irrespective whether you know the specifications or not. The fact that you've seen it is considered to be valid. We're going to build on that and discuss that particular issue, inshallah. Now, واشتراط الوصف هنا فيما غاب عن العقد غيبة حقيقية حسية فهلا نشرط الوصف فيما غاب غيبة معنوية بمعنى كون مستورا عن الأعين مع كون السلعة حاضرة. So that's the contention that I have. So for example, I always have difficulty in locating my phone. Oh no, I gave my phone to somebody. What can we use, Sayyidina Yahya? Do you have a phone? Bismillah. So basically you have this phone here. So now technically speaking, in terms of the Shafi school of thought, I sell you this phone. The sale is going to be valid. Why? Because you can see the phone. The challenging aspect is you don't know what the make is, and you don't know the specifications of the phone. My contention is that when something is which you have seen, but it's absent now. So you've seen the phone, I meet you later, and I tell you the phone that I showed you earlier on, I'm selling that phone for 2,500 rands. What must I do at the point of sale? I must describe the specs of the phone to you. So it's really absent. What about when something is absent in what sense? Not in a real sense, but in a metaphorical sense. In other words, you don't know the specifications. So when you don't know the specifications, my argument is that the seller should highlight the specifications to the buyer. And the buyer, once he's cognizant of the specifications, and then they enter into an arrangement. Particularly in today's time, what also happens is that you have, I don't know what to call it. You have an original, for example, Samsung. This happened to my sister. Samsung, and then you have nowadays the prototype. I'm going to call it a prototype, for lack of a better word. Is there another word for it? A replica. But the replica have grades. Just in the week, a person asked me, is it permissible for me to sell a certain brand, but the replica is graded as an AAA replica? That was his words. So in other words, that there's very little difference between the original and that. So my sister bought, it must have been like a AAA replica of a Samsung. It was only when she was like downloading some applications onto the phone that she came to discover that there's no compatibility. And she contacted the seller, and then the seller divulged, no, it's not an original Samsung, it's an AAA replica. Now these things, when you see the phone, you're not going to know about it. It's only when somebody discloses that to you that you actually know exactly what you are buying. So because the nature of the commodity has changed, whereby it's more important for you to know the specification as opposed to viewing the item. So viewing the item might leave a lot of unknown elements, and which could amount to contractual risk, which will compromise the validity of the transaction. So therefore, and Allah subhanahu wa ta'ala knows best, we advise that when you're purchasing something, that you, number one, you view the item, that would satisfy the madhab, our school of thought, but also you familiarize yourself with the specifications of the item. It reminds me, this doesn't relate to our discussions, it's coming to something later that talks about, you know, they call it a cooling off period. It's a legal term, cooling off period. So when you purchase something under the Consumer Protection Act, they allow you, it's something superimposed by the government in the form of bylaws. So the Consumer Protection Act, when you buy something, you have a 7-day cooling off period. Something that has happened at the time of the Prophet ﷺ. A companion came to him and said that whenever I purchase something, I am deceived. So the Prophet ﷺ said to him, whenever you purchase something, you should say, La khilaba, wali al-khiyar thalathat ayyam. You know, there shouldn't be any deception. So why I'm mentioning that narration is because it emphasizes in a roundabout way that when we purchase something, we need to be familiar in terms of what we are buying. We're spending money in lieu of a service or in lieu of a commodity. When you spend that money, view the item and familiarize yourself with the specs of that particular item. كان علماؤنا يقولون قديما لم يكفي الوصف وإن استقصى لأن وراء الوصف أمور تدق ولا يوقف عليها إلا بالمشاهدة. So what I'm doing now is we're trying to sort of like go between an agrarian society and a modern society. So before, our scholars would say that if you haven't seen something, no matter what extent the item is described to you, the description is always going to fall short of a sighting. The description is going to fall short. In today's time, looking at the nature of the commodity, we offer the following. هذا الكلام لا شك أنه صح فيما مضى. There's no doubt that this principle was valid in terms of times gone by. لكن في كثير من مصنوعاتنا الحديثة. However, in today's time, in many of our modern مصنوعات products, in modern products, actually the opposite of his astak is more true and more relevant. And what is that? That when you see something, the citing is not going to inform you what the mention of the specification is going to inform you about. So like the tables have turned, not because our scholars got it incorrect, but because times have changed. commodities have changed. The nature of the commodities have changed. In times gone by, most commodities were non-fungible, like handmade, and you only had one of a given type of thing. In today's time, it's all become fungible. And then the nature of the commodities that we're using is that the specifications are more important than, and the specifications is something which is hidden from the eye in most instances. So what is going to suffice for that? The specifications. So when a person is buying something, to remove that unknown element, one must be au fait and familiar with what the specs are, the specifications are. So what do we say? لكن في كثير من مصنوعاتنا الحديثة, in many of our modern day products, عكسه أصدق. The opposite is more true. وهو أنه لا تكفي المشاهدة. That simply viewing an item is not sufficient. لأن وراء المشاهدة, because beyond what you can see, beyond what meets the eye, is أمور, is matters تدق, which are like subtle and very important. That's a flash drive. Somebody's going to throw you with that flash drive. That's what they told me. Flash drives, they give me something, they copy in a flash drive. Flash drives have very little value in today's time. You can afford to lose it. But then there's something that looks exactly like a flash drive, but it's going to set you back 3,500 or 4,000 rands. But how do you know the difference? The difference you can't ascertain from looking at the item. The specifications must be mentioned. لا يوقف عليها إلا بالوصف والله أعلم. That you're only going to discover that in terms of the specification. So the idea, again, one of the primary ideas was to build a bridge, or to facilitate that bridge between what's in our classical fiqh and a modern application of things in Allah subhanahu wa ta'ala knows best. That doesn't take away in terms of where our school of thought stands, in terms of when you see something as you suffice. It's valid, the sale is valid. This is an advice in terms of look at the item and familiarize yourself with the specification. I'm speaking into a camera now. The camera has a lens. That particular lens has specifications. I can't ascertain it. I must read the specs. So it has a wide lens, allowing more light in, and therefore it takes a particular quality photograph or video. If you show me two of the same things, I wouldn't know. It's just looking at it. So this is why this particular aspect is important. Wallahu a'lam. Wa na'tarifu. Bismillah.
I'm saying that in terms of, Mala mentioned the example of the agrarian society, and that if we look in our modern context, then that's completely opposite. Well, not completely, but it's mostly opposite. But I think sort of the same thing exists when you look at the possibility for deception. Specification has more room for deception than viewing. So if you were to be satisfied with what you saw, they could still deceive you in terms of the specification. They tell you, look, maybe it's a terabyte, but it's a 500 gig. And even if they tell you the specification, you still can't, at the time of contract, you still have to sort of take a leap. When you're seeing it, that sort of the asal of at least you saw it remains. If Mala gets
my contention would be that, ascertaining whether it is a terabyte or not is something which is hidden. You can only, if you test it and you plug it into a computer, you'll be able to ascertain it. And in light of what is going to come also, we find that in terms of, again, your Consumer Protection Act, in terms of the labeling, that it must be mentioned. There are certain things, there are loopholes around it, whereby the buyer can potentially be deceived. But generally what happens is that it is mentioned over there. And so the specifications, I'm thinking to myself, the specifications, if I buy something on the following specifications, when I test it, I find that it doesn't meet the specifications. So when you purchase something and they mention the specifications, and now what happens is your ability to return the item because the specs weren't met is greater. So when a person commits to a spec, because the whole idea behind, like, when you don't see something or when you don't know the specs is, look, you've sufficed with seeing it. I sold you the item and I didn't say anything. I didn't say new, old, second-hand, roaming, no roaming, whatever the case may be. So specification is like a commitment. And in terms of the common law, South African law, you are bound to mention those things in terms of specification. Wallahu a'lam. ونعترف أن هذا قد يختلف باختلاف غرض المشتري بأن يشتري السلعة لظاهره دون ما في كيانه أو لرضاضه ويقول أشتري كما هو. We also acknowledge at the same time, you don't want to be too pedantic about the specs. Sometimes somebody is buying something and he's actually not interested in the specifications. For example, he's buying just the cover. He's only interested in the cover. He wants for example, he's buying the laptop, but he's not interested in the specifications of the laptop. He's interested in the cover. So the specs then need not be mentioned because of the interest, the vested interest of the buyer, and he's clear about it. I'm only buying the shell. Wallahu a'lam. أما القدر فهكذا الحكم في قدر المعقود عليه فلا يجوز أن تقول مثلا بعتك بضع جوالات مقابل ما تراه مناسبا. It is not permissible for a person to say بعتك بضع جوالات, I'll sell you a few phones مقابل ما تراه مناسبا, and you can give me whatever you want to. And this is quite common. A more common example would be when one of the contracted items, either the commodity or the price is fixed, but the other one is left open-ended. I sell the phone to you, you can give me whatever you want to for it. Some of our scholars, there's a difference of opinion. They say, give me a market-related price. Now, the market-related price might be fixed, but at the time of the sale, when the sale is enacted, then the buyer and seller, they're not familiar with what that is. So then according to our scholars, they say it's not permissible. Though it is, technically speaking, it's actually fixed because it's a market-related price. For example, I sell you my car. Now, you know, a car has like a set. There's different tiers of pricing. So let's say the retail price. Muhammad Tayyib, what do they call the price that, not the market value? You know, like if I purchase a car, right? And I want to resell it to the very agents I bought it from, like Toyota, what do they call that price? Trade. So trade. So I'll sell it to you at trade. So I have a car, I sell the car to you at trade. If you know exactly what the trade is and I know exactly what the trade is, then no problem. But if you don't know and I don't know, despite the fact that in real terms, the trade price is known, like you can call Market Toyota and they'll give you exactly what the trade price is. It's like a fixed price at a given point in time. So you get different situations. If it's the trade price, then if the buyer and seller knows what the trade price is, then good and well. But if they don't know what the trade price is, it means that there's an element of unknown there. Wallahu a'lam. ومثل هذا كثير الوقوع والحصول في أوساطنا. And this type of sale is كثير الوقوع. It happens quite often في أوساطنا, in our circles, you know, amongst us as Muslims. So what happens is, if you were to ask a person offhand, Muslims generally, are they optimistic about dealing with one another? Like buying and selling to one another, serving as a service provider for one another. Generally, you find that people answer in the negative. No, not. Why is it? There are certain contributory factors to that. It's because we don't have a good history of dealing with one another. A simple example would be that, and it probably happens to many of us, I'm talking about the concept of interacting with one another. We should interact with one another professionally, for lack of a better term. So I borrow money from my mother. At the time that I borrow the money, it's a clean contract. In other words, I'm the borrower, she's the lender. Let's say we make an agreement, we will discuss in terms of fixing up a time for it. But let's say we go with the Maliki view, which says that when you borrow money, you can fix a repayment date. So we fix a repayment date based on the Maliki school of thought. And the repayment date is going to be the 1st of December. When it comes to the 1st of December, then what happens? I'm no longer the borrower and she's no longer the lender. I'm the son, is my mother. So it becomes a challenge. And now what happens is, so that's fine for now. But next time I want to borrow money from my mother, she's not going to be too willing to lend the money to me. So the way we conduct ourselves with each other in terms of contracts, it doesn't create a good platform for continued interaction between ourselves. And this is basically what happens. It happens many times. We sell something to somebody, we don't fix the price, so we're part of the problem sometimes. We don't fix the price, we don't fix the commodity, we don't fix the terms. Why? Because we take it for granted, we're brothers, there's an understanding. But your understanding and the other understanding is two different understandings, and this leads to problems. وإن تعجب فعجب أنك لو رحت تنصح هذا العاقد بتعيين معقود عليه يرفض يتساءل. So if you surprised about this particular phenomenon, that we have sales happening within our Muslim community, and what happens is the price is not determined, the counter value is not determined, it's like really very unknown. So وَإِن تَعْجَبْ فَعَجَبٌ, if you surprised about that, then what would even surprise you more would be لو رحت, if you were to go تنصح هذا العاقد, you advise this particular contracting party بتعيين المعقود عليه. So look, you want to sell this, even if it's your brother or sister, whoever the case may be, then specify the contract item. يرفض يتساءل. He will refuse to do that. He will say, ألسنا إخوانا يثق بعضنا بعضا. Aren't we brothers that, the one trusts the other one? So now what happens is, فهو يرى عدم التعيين من الأخوة. So if you really look at the psyche of our psyche, he says, not stipulating it, in other words, not doing it properly, that's a sign of brotherhood and the dictates of brotherhood. Whereas the Sharia actually considers what you are doing as a cause. Al-haliqa. Halaqa means to shave off, like you shave off the head. So when we don't interact with each other properly, clearly, and all the terms are known, the Sharia considers that to be something which removes brotherhood, like, you're shaving your hair off and like a razor removes your hair. That's like what removes our brotherhood. And many times people are, and it happens over and over, the cycle repeats itself. To do something properly from the inception, it may be difficult. But what's even more difficult is when things go pear-shaped and now you're sitting with a bigger problem down the line. So this is very important. Sometimes we're uncomfortable. That's why perhaps now after this preamble and discussion, we can mention the words of Mln Ashraf Ali Thanwi rahmatullah alayh. He says, تعاشروا كالإخوان وتعاملوا كالأجانب. He says, when you live with one another, live like brothers. Live like brothers. Like, this is my brother. What belongs to me belongs to him. But when you deal like strangers. Now, this must be clear, because Allah didn't say that, when you don't devour the wealth of one another, the stranger's wealth. It applies to everybody. So whether it's brothers, sisters, whoever we are, to the best of our ability, to ensure that when we enter into a contract, it's a contract. So we clear in terms of the buyer, the seller. And to the best of our ability, if it is that we have entered into a type of arrangement that I can't buy, rather make amends for it now than having to make amends for it in the year after in terms of our contract. Very important. One of the scrolls that Allah SWT has a hands-off approach to would be the rights of one brother to the next brother. You come, you haven't prayed, you haven't fasted, you haven't given your alms tax and so forth. Allah is oft forgiving. Allah, you can't say like genuinely. Allah SWT, Inna Allah la yukhliful mi'ad. Allah doesn't go against His promise. And Allah's promise is that if you udu'uni astajib lakum, ask of me, I'll forgive you. Allah SWT will forgive you. I was listening to a talk of Sheikh Muhammad Saeed. He says that Allah doesn't think twice about forgiving you. Absolutely. Allah, in Sahih Muslim, there's a number, copious narrations that talk to a person appearing in front of Allah SWT. Allah SWT says to him, you remember on such and such a day that you committed such a felony. Then the person will say, I acknowledge that. Then Allah SWT will say to him, like I covered you in the world, I cover you now, enter into paradise. So in other words, Allah SWT doesn't think twice of forgiving you. But what Allah SWT what takes issue with, and the only severe punishment He's threatened the person with, when the person is proud, arrogant and haughty. Allah SWT doesn't take kindly to that. But when you slip up and make a mistake, Allah SWT is prepared to forgive you. However, all the scrolls that Allah is going to have in front of Him, Allah will say, look here, this scroll, I can wipe this slate clean. I can wipe that slate clean. There's nothing I can do about that. It's almost like when you go for your fines, I can scrap this, I can scrap that, but there's a warrant out for your arrest. I can't do nothing about that. So then Allah, the warrant of arrest on the scrolls of Allah is when a person has perpetrated against another. Allah wants to say, look, I have a hands-off approach. That's between yourself and your counterpart. There's nothing I can do about that. So therefore it's important for us to resolve those issues. So prospectively, to contract like properly and clearly, and a good measure would be that, I've never dealt with this person before, but we've always been good friends. My aim is that after this deal, inshallah, we can still be good friends, which ensures that I'm going to do my level best to ensure that this deal is done proper. Now, وكم شكا طالب الصعوبة التي يواجهها في تطبيق هذه المسائل فيما بيننا نحن معشر المسلمين وشعوري بغاية التحرج، فأقول له: أولا، ما يترتب عليه العقود الفاسدة أحرج، وثانيا لا يكلف الله نفسا إلا وسعها والله سبحانه وتعالى أعلم. تتمة للشرط الخامس. So we basically looked at the fourth condition, and now we have like a completion to the fourth condition. Mln Yahya, should we read through the completion, or I see we're on to 40 minutes now? Normally our class is like 40-45 minutes. So should we stop here, inshallah? And we look at the questions that have come through, and then we continue from there next week. نكتفي بهذا القدر. إذا قال مولانا به الكفاية ففيه الكفاية إن شاء الله بإذن الله سبحانه وتعالى. Mln Irshad, you're normally responsible for the questions and so forth. If there are any questions on the platform or from the brothers in class, inshallah, we'll take those questions and then we'll conclude for the night.
Assalamu alaikum wa rahmatullah.
Assalamu alaikum, Habib.
No questions, Mln.
Barakallah fikum. Marhaba. There are no questions on our side here also? Mln Yahya, you asked the questions to my in-class, no? Barakallah fik.
Well, there was one that came last week. I think it bears relevance to what Mana mentioned here.
If you could just sit a bit, there's a bit of feedback coming from the mic.
Barakallah fik, Habib.
What Mana mentioned here in terms of ikhtilaf al-aghrab. But I think the question might also come when we speak about uyub. The question was regarding footstones. So I don't know if I should pose it now, then I can see whether or not can maybe be deferred. What the question was that the person says they sell it as is, right? And they view the item. But at the same time, the seller knows that there is a latent defect in it, which cannot be known even via seeing it. Then in terms of the validity of that sale from the side of the seller, will he be sort of like akim in that regard?
That's a very interesting question. Then look, if the seller is a Shafi'i and then selling something, and you selling something footstools whilst cognizant of the defect, is not valid. The footstools clause doesn't get you off the hook, according to the Shafi'i school of thought. So, for example, if I have a book, right? I know there's a few blank pages in the book, or I know the book is maybe minus an index, so that's a defect. So then I say to him, selling the book to you as is. So according to the Shafi'i school of thought, the as is clause doesn't get you off the hook. Look, I genuinely don't know, and then I sell it to you, look, I'm selling it to you as is because I don't know of any defect within the item. Then that's an honest sale. But if the person knows of a defect within the commodity, and then he says, I sell it to you as is, and he doesn't disclose that particular defect, and then it's considered to be an act of treachery according to the Shafi'i school of thought. Because the narration, Man ghashana falaysa minna, whoever deceives us from amongst us. And it comes when the Prophet went to the marketplace, and a person had a heap of grain or cereal, and the person put his hand into the grain, and what happened was when he pulled his hand out, then it was all wet and moist. So he said, Ma hada ya sahib al-ta'am. What is this, food seller? So then the food seller said, Prophet of Allah, it got wet from the rain. So then the Prophet said, Man ghashana falaysa minna. So that's not going to get you off the hook. According to the Hanafis, I remember when we were doing that in terms of Quduri, then one of the students was from Mauritius, and he had an old Toyota. So the teacher said, there's a Kalahari Ferrari, not a Ferrari, Kalahari Ferrari. So if he says to you, look here, this is my car, I'm selling it to you as is. He knows, look here, there's 101 problems with the car. And he says, look here, I'm done with this car, I'm selling it to you as is with all of its, issues. According to the Hanafi madhab is going to be valid. According to the Shafi madhab is not going to be valid. Currently now, as explained by Manata, he says currently, like in terms of South African law or the bylaws, then it very much supports the Shafi'i view. Because remember now, the Consumer Protection Act is geared and it's more like supporting the buyer as opposed to supporting the seller. Previous prior to that was caveat emptor, let the buyer beware. Because according to the law, you go to a court of law and then all the lawyer argues is that you should have done your homework. As the buyer, you should have done your homework. The onus was, but now the onus is more placed on the seller. The seller must do this, must do that, Like for example, if somebody buys something on credit and they didn't realize that if I purchase it cash, it's 10,000. But if I buy it on terms, it's going to cost me 50,000. Afterwards, he comes to realize it's 50,000, he wants to cancel now. Then they simply tell him, no, look. But in the current, under the Consumer Protection Act, if they didn't explain to him that cash is 10, and despite the fact that you're only paying 100 rands a month, in long term it's going to be 50,000 rands, then he has grounds to stand. Why? Because the onus lies with the seller as opposed to with the buyer. Allah subhanahu wa ta'ala knows best. So, Jazakumullahu khairan. We'll end on that particular note, inshallah, and we'll continue next week, inshallah, same place, same time. Barakallahu feekum jami'an, wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.